And we return to our top story tonight. Former Transport Minister S Iswaran has been sentenced to 12 months jail in a landmark corruption case. The judge, disagreeing with submissions from both the prosecution and the defence, almost doubling the jail term sought by the prosecution. Now, for more on this, I'm now joined by Associate Professor Eugene Tan from the SMU School of Law. Prof, it's good to have you here with us.
Always a pleasure, Ada.
So, prosecution had asked for 6 to 7 months jail. Defence had argued for no more than 8 weeks. But the final sentence given was much higher than that. How common is a situation like this? And essentially, what is the judge hoping to achieve with this decision?
I don't think the sentence, although it's almost double what the prosecution had asked for, is very surprising. The judge will obviously hear the arguments that are put forth by both the prosecution and the defense, but the judge is not bound by those arguments. Ultimately, what the judge is trying to do, right, is to determine, looking at the facts of the case, looking at the law, to be applied, what would be appropriate for the ends of justice. And I think in a very carefully worded judgment, the judge took the position, that even at 6 to 7 months, that would be manifestly inadequate, taking into account, the facts of the case. I think the judge was primarily concerned about the harm that had been done as a result of, perceptions that the trust and perceptions that the integrity of the public service, had been compromised, and the fact that Mr Iswaran, abused, the office that he held, as well as the trust, that is reposed, in the office of a cabinet minister. So I think when we look at all this, I think the judge was very mindful, in making the case as to why, a much stiffer penalty was merited, on the facts of the case.
Looking at the charges, he was charged under Section 165. That carries lower penalties than the Prevention of Corruption Act, or PCA. Would you say that the PCA would need to be reformed or reviewed, given that the bar to prove someone corrupt has been set too high?
Well, I don't think the bar is set unnecessarily high. I mean, when we look at prevention of corruption offences, they relate to corruption, which one can simply put as, a favour exchange for another, right? So in this case, was a decision influenced as a result of, a bribe that was given. I mean, I'm talking about a Prevention of Corruption Act case. But we have in Section 165, which is not in the Prevention of Corruption Act, but it deals with situations in which even though where favours are not exchanged, we are looking at a situation in which the public servant could potentially put himself in a position of conflict of interest. And so I think when we look at the judgment, I think when we look at this case in its totality, I think there is no doubt that there is that utility in having Section 165, because I think it deals with the perception of trust and confidence, in public institutions being undermined. A question was posed in Parliament about 2 years ago, on whether Section 165, could be incorporated into the Prevention of Corruption Act. And I think the response, from the Home Affairs and Law Minister, K. Shanmugam, was that it is useful to have a variety of measures, to deal with, the very wide spectrum in which conflict of interest could arise, in which the public sector's interests could have been subordinated, to that of another entity or individual. So I would say that, we have, in a way, a range of offences, to deal with situations in which, a public servant, would not be doing his duty in the interest of the public.
Has anyone ever been sentenced under Section 165, Prof? And do you see this as setting a precedent for future cases charged under Section 165?
Well, this case, the case today, is the first since independence. There were two other cases, according to the research, that took place in the 1950s that involve police officers. But this is the first time that we have seen, we have a judgment, and it certainly is precedent setting, right? I think that the judge, for example, explained that the starting point, where someone is convicted of a Section 165 offence, is that there must be a general deterrence. The sentence must reflect a general deterrence, and that a custodial sentence, is also the starting point. So I think, in that sense, this precedent becomes an important one. I think it clarifies the law, and so I think, that's the utility of this case.
And before we go, Prof, the jail term is expected to begin on Monday. Do you think there should be an appeal? And if so, what would the process look like in terms of the timeline? Well,
Mr. Iswaran would be well advised by his lawyers, as to whether, an appeal would be merited. I think we're looking at a timeline of, anything between 3 to 6 months. But looking at the indications given in court today, particularly, the fact that Mr. Iswaran, will report to the state courts on 7th of October, that it might seem that, he will begin his custodial sentence, but he can still appeal. He has up to 14 days from today, to appeal against his sentence. So I think, everything is still in flux. I think he will take, the advice, consider the advice of his lawyers, but it's within his legal right, to appeal, if he thinks, for example, that the sentence is wrong, or that, it is excessive.
Okay, Prof, always appreciate you speaking with us. Thank you so much for that. That was Associate Professor Eugene Tan from the SMU School of Law.